Good morning, everybody, or good afternoon, depending on where you are. My name is JoLynn Scharrer. I am a shareholder at Hunt, Ortmann, Palfi, Nieves, Darling, and Ma. I am the head of the employment law group at the firm. We are a construction boutique firm, but I have the pleasure of doing a lot of work with our clients, our existing clients, and other clients who are part of all facets of the construction industry. And not exclusively, but many of them are. I have been practicing for nearly 35 years, and about 30 of those have been in the labor and employment space. And today we're going to be talking about 10 topics, I should say, construction employers need to know about. And I have generated this presentation based upon my direct experiences with clients, what I have seen to be pitfalls or areas of improvement, areas where construction employers might not know everything they need to know in order to protect themselves from claims and litigation. So that's going to be one of the focuses today. Here's my standard legal disclaimer. This is an educational webinar. The materials are presented solely for education and training purposes. And I am not establishing an attorney-client relationship with any of you here today, although that is something that often grows out of presentations like this, happily. Today's presentation, we're going to talk about some hypothetical scenarios. There is some case law sprinkled within the presentation. Again, the goal is objective and compliance. Compliance on the front end is going to help you avoid litigation on the back end. So please feel free to ask questions if you need to. You can include them in the there's a Q&A button on the banner that you can press and ask a question, or you can include it in the chat. Feel free to do that during the course of the program. The reason I say that is because I have a lot of information and I'm going to try to move through some of it quickly because I want to be able to cover everything. And I have a feeling that with some of my other webinars, if you've attended them, you know that I like to move very quickly through a lot of information because I like to share as much as possible. And I will also address questions and chat comments at the end of the presentation as well, to the best extent that I can. This is me. I've already introduced myself. So here's the outline for the program today. And these are broadly the 10 topics that I highlighted to discuss today. The first topic is employees versus independent contractors. We're going to spend a fair amount of time on that, in part because that is the number one topic of litigations filed in California most recently. Two, we're going to talk about important wage and hour laws. Right now, my practice includes about 80% of wage and hour and PAGA litigations. It is a huge area of the law right now, and I think a lot of the litigations have grown out of the pandemic. It's rampant right now. I am a settlement officer for the LA Superior Court, and I conduct settlement conferences for parties every single week. And I can tell you that the great majority of those cases are wage and hour cases. And the great majority of those cases should be settled because they should not be in the system. And I'm happy to be helping to get those cases resolved for the parties for much less time and money. We're going to talk about timekeeping and employer best practices and what that means. We're going to talk about documents, handbooks, policies, other communications with employees, and why that is so important and how that can help an employer in defense of a case. We're going to talk about harassment, discrimination, and retaliation, especially in California. This is a huge topic. It's also one of the top types of litigations filed, and I have a slide on that later. We're going to talk about employee discipline and performance, and again, the importance of documentation. We're going to talk about claims and litigation, PAGA cases, what that is, what it means, class action litigations, and what it looks like to litigate them and how to resolve them. We're going to talk briefly about immigration issues and what the most pressing or important issue is for employers, especially upon hiring. We're going to talk about pandemic policies and injury and illness prevention plans, which are mandatory in California and are probably mandatory in many other states. And then we're going to talk about, well, what's the importance of insurance in dealing with all of these other issues, because insurance can be a great source of help to employers to the extent they are faced with a claim or a litigation. And then in the end, we'll address questions. I just received a question. Will the handout of the slides be sent out? It will. I can email a copy of the presentation to you. I received an email list, but if you put your email in the chat, I'll be happy to send that out to you. Okay, so let's jump into the first topic, employees versus independent contractors. This slide includes a definition of employees, any person employed by an employer, which sounds like a ridiculous definition, but there is a reason for explaining the difference. Independent contractors and volunteers are not employees because they are not paid and subject to control by the employer. Independent contractor is someone who is in business for himself or herself or has a separate business entity. Independent contractors perform work that requires a specialized skill or a trade that's not part of a company's regular business. And we'll get into much more detail about that. In California, Labor Code Section 2775 talks about what an independent contractor is. In California, there is a presumption that you are an employee, and that needs to be overcome by the employer by proving that someone is an independent contractor and not an employee. And as I said, this is the #1 cause of complaints filed right now in California. A person providing labor or services for remuneration, being paid for those labor or services, is always considered an employee unless the employer can show that the person's free from control and direction by them in connection with how they're doing the work, what they're doing, when they're doing it, under the contract or the agreement that they have for the work. If the person performs work that's outside the usual course of the hiring entity's business, and we'll talk about examples of that as well. And if the person is customarily engaged in an independently established trade, occupation, business of the same nature that's involved in the work performed. The ABC test. So for those of you in California, you've probably heard a lot about AB5 and the Dynamex case and all of the litigation in California that has been going like hotcakes for the past couple of years. The ABC test is a test that arose out of the Supreme Court case of Dynamex, and it is a 3-part test, literally parts A, B, and C. It couldn't be more basic than that, that the court has said will determine whether a person is an employee or an independent contractor. The first part of that test is whether the worker is free from control and direction of the employer, the hiring entity, when they're doing the work. So the hiring entity has the burden to show that the worker is free from the control in order to satisfy this part of the test. And this really is the most important prong of the test for purposes of determining whether someone is an employee or an independent contractor. If a worker is subject to a certain amount of control by the business, and that control is exercised equally between them and other employees of the business, guess what? That independent contractor is going to be considered an employee in the eyes of the law. Depending on the type of the work and other factors that we're going to go into, the details of the work, there are a number of factors that can be considered a number of facts, but all of the control doesn't need to be vested with the employer, but there are certain types of factors that will weigh in favor of the employee being considered, the worker being considered an employee as opposed to an independent contractor. And so it just depends on qualitatively does it look like something different than the control that the employer is exercising over their employees in the business? Part B of the Dynamex test, the ABC test, is does the worker perform work that's outside the usual course of the hiring entity's business? So the hiring entity, again, has the burden to prove this. And contracted workers who provide services in a role comparable to that of an existing employee, so they're doing the same type of thing that the employees at the company does, will be viewed as working in the business and are more likely to be considered an employee as opposed to an independent contractor. So an example, when a store hires an outside plumber to repair a leak in their bathroom on its premises, that is not the retail store's normal business. It's not something that they're not providing that service to the community. So that would clearly be a situation where that person is an independent contractor. If it was a retail store hiring someone to do advertising or merchandising for several locations, likely that person is going to be more considered an employee because they are undertaking a business function that is part of the retail store's regular course of business. And another example of that on this slide is, for example, when a bakery hires cake decorators as opposed to maybe someone to, a contractor to renovate their business premises. That's another example. The third part of the Dynamex test is part C, is the worker customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed for the hiring entity. So again, the hiring entity has the burden here and has to prove that they're engaged in an independently established trade, occupation, or business. What does that mean? Does the independent contractor have their own company? Does the independent contractor hire their own employees? Does the independent contractor independently market? Does the independent contractor engage in separate marketing and promotion of their own business? Do they work for other customers aside from the alleged employer? All of those factors go into consideration of whether this portion of the Dynamex test can be met. If there is an independent business operation, and that would weigh in favor of someone being an independent contractor, was that business in existence before the relationship was started between the employer and the worker or the business owner? If that's the case, then that fact would weigh in favor of someone being considered an independent contractor. And the fact that the business did not come into existence until the establishment of the relationship would weigh against it. And that's the Garcia case. Again, usually someone who is properly considered an independent contractor will have their own incorporation, their own licenses, their own marketing scheme or business promotion scheme. They will offer their services to other customers aside from the potential employer. And if they are working only for the potential employer, then it's pretty likely that this part of the Dynamex test is not going to be met. Believe it or not, the court in Dynamex explained that there were some exceptions, specifically if the legislature or the IWC has made particular determinations about whether particular trades or classes of work are excluded from the ABC test. It could very well mean that they are intended to be considered employees in every scenario, or that the ABC test doesn't squarely fit with how we should consider whether they're employees or independent contractors. One example of this, and it's been hotly litigated, and it was involved in AB 5, and in fact, I was at a labor commissioner's office up north at one point when AB 5, there was a huge outcry against it, and there were a group of independent haulers, truckers, who were actually picketing. And I spoke to some of them about why they were opposed to AB 5. They actually wanted to be considered independent contractors for a number of reasons, and some of which were tax related. But it surprised me a bit. So there's been a lot of controversy about what types of businesses or specialty skills or trades will be accepted or included within the umbrella of the Dynamex case. In those circumstances where either a statute or an IWC wage order or a court determines that this ABC Dynamex test doesn't apply, there was a prior test from a case called Borrello that they said the Borrello test would apply. Well, if the Borrello test was great, why fix it, right? Why change the law? Why change the test? The ABC test includes three considerations, three general factors, and is supposed to be easier to apply than the Borrello test. And the Borrello test is much more involved. So here's an example of some occupations where the Borrello test is going to apply automatically because the labor code says that the ABC test does not apply. And that is attorneys. I mentioned the fact that they're architects, landscape architects, because very often construction employers are dealing with those trades, engineers, accountants, direct salespeople, manufactured housing salespersons, and then some home inspectors. So considerations for people doing work in these spaces who you might be working with, whether they're an employee or an independent contractor, is going to be determined by the Borrello test in California. The Borrello test, as you can see, and I think there are 3 slides, relies on consideration of multiple factors to determine whether an employer has control, and that's the bottom line. Does the employer have control over the person doing the work? There are a number of factors. There is not one factor that is more important than the others. It's a collection of factors, and it could be a majority of these factors apply or rule in favor of someone being an employee, or a majority of the factors apply and determine that someone is an independent contractor. So let's go through those quickly. Is the employer performing services distinct from that of the employer's business? We talked about that. That is a part of the ABC test. Is the work a regular or integral part of the employer's business? Who supplies the instrumentalities? So, computers, servers, telephones, tools, work location, car, things like that. Who's supplying that? Is it the independent contractor has their own materials, instrumentalities, and they have their own work location where the work is being done, or are they reliant on the employer's place of business and property? Has the worker invested in the business that equipment or materials are required? So again, if you're an independent contractor, you've probably purchased all of your own equipment and materials so that you can conduct your business, whether it's for this employer or another client. Does the service provided require a special skill, one that is not part of the ranks of the employer's employees? Is it the kind of occupation and whether the work is usually done under the direction of employer, or is it done by someone without supervision? And the list continues. The worker's opportunity for profit or loss, depending on their managerial skill. If you're an independent contractor, you are in charge of the finances with regard to your own business entity, if there is one, or your own business operation. How long are the services going to be performed? Are we talking about a month-long project? Are we talking about a contract for a year? Or are we talking about an ongoing relationship that doesn't have a set duration, doesn't have a cutoff point? And is there a lack of clarity about how long it's going to last? The method of payment, whether by time or by job. Also, is the person getting a paycheck or something akin to a paycheck, or is the person submitting invoices that will be subject to payment later? Is it a standard amount of money each time, or does it vary by the work that's completed or the time that's spent? Does the employer have the right to fire the person at will, or would that give rise to breach of, for example, an independent contractor agreement? If it gives rise to breach of contract for an independent contractor agreement, then it's more likely that the person is an independent contractor. And intent is a big part of this as well. I have several clients who want to enter into an independent contracting relationship. And so I start asking in questions. I start asking these questions like, you know, the factors for the ABC test, or specifically the Borrello test, and say, look, you know, this is what it comes down to. Have you considered how these things are going to be handled? And are they going to be addressed in your written agreement? Are you going to have a written agreement? If you both expect that the person providing the services is going to be an independent contractor, you should have a written agreement that sets out answers to several of these questions, so that there can be no question later on that the person is considered an independent contractor from both of your perspectives. Why is that important? The main reason it's important is because you don't want an independent contractor coming back and saying, well, yeah, they considered me an independent contractor, but I was really an employee and I worked 50 hours a week for a year and I never got paid overtime. In fact, I was never paid for expenses. I was never paid overtime. I was never permitted to take meal or rest breaks. The fact that someone could turn around and say, well, I was an employee, would potentially avail them of all of those things that we're going to be talking about in a few minutes. And if there's a determination made that they were really an employee and they were subject to wage and hour laws, then you've potentially bought yourself massive penalties and damages in a claim for someone who you could have been clear about what the relationship was from the get-go. And it's really important to have those relationships spelled out in a written document and be very clear about where you fall when you consider all of these factors, whether under the ABC test or the Borrello test. It's really important that you are able to manage how the interpretation of these factors is going to go for you if there's a claim made. As I said before, Borrello is a multi-factor test. It doesn't rely on the applicability of a single factor. And in fact, courts have been all over the place in how they interpret it. So some courts will look at whether there's a majority of the factors met. Some courts will give a greater weight to some of the factors as opposed to others, but it's really going to be determined on a case-by-case basis. Again, I mentioned this earlier, why the change? Whoopsie, let me go back. Why the change? It was a common perception that the Borrello test was too unwieldy to really manage and to try to predict what the outcome would be on a case-by-case basis. The Supreme Court in California determined that the ABC test was a shorter and easier test to manage and to apply to each factual situation. Again, I think regardless of whether you're using the Borrello test or the ABC test, the important consideration is that you're thinking about these things on the front end and that you are addressing them in a written agreement with whoever you're intending to do business with, whether they are an employee or an independent contractor. And if both sides want the person to be considered an independent contractor, then you need to do your homework and your due diligence up front to make sure that that's not going to be undone later if circumstances change. Let's move on quickly since oh boy, time's a wasting. Wage and hour issues, another huge issue for employers, construction employers. And I can tell you that this is the number one problem that I deal with clients on a weekly basis. It's always an issue. I have several litigations involving wage and hour issues for construction clients. And the best advice that I give to clients is a little prevention upfront goes a long way, and it's going to cost you much less upfront if you make sure that you're in compliance, as opposed to on the back end having to deal with litigation, especially wage and hour and PAGA litigation. So the wage and hour issues that we're going to discuss today, and I can't hit on all of them, are paying less than the minimum wage, unpaid wages or overtime, late payment at separation from employment, whether someone is quitting or they're being laid off or they're being terminated. Here's the biggest one: denials of meal and rest breaks, or uncompensated breaks, and what I call also working off the clock, failure to reimburse employees for work-related expenses, and improper practices concerning vacation pay and time off, and then last but not least, sick time, which is can be a very complicated issue in California. Paying less than the minimum wage. Labor Code Section 1197 requires employees to receive a minimum wage fixed in the state by the Labor Commission or by state and local municipalities. And it really does go both ways. And because there's a federal minimum wage, there's a California state minimum wage, and then there are local minimum wages. For example, here in Pasadena, there's a Pasadena minimum wage. And you need to make sure that you are in compliance with all, which is relatively easy, because there are well publicized changes to minimum wage law that are easy to discover. I know that they're always changing. I know that they changed in July, and they're going to be changing again. There is a push to increase the federal minimum wage as well. That hasn't happened yet. It's in the works. But this is, and why is this important? Obviously, because everyone deserves to be paid the minimum wage that is established either by federal, state, or local law. And if you fail to do that, and there are a number of ways you can fail to do that, you can be subject to penalties, and you can be subject in California to liquidated damages. There's a specific statute that requires the payment of liquidated damages if you willfully fail to pay someone minimum wage. Labor Code Section 1194 allows employees to file a lawsuit to obtain the minimum wage payments that they did not receive, or overtime pay that they did not receive. They can sue for the back pay. They can sue for liquidated damages. They can sue for interest. And importantly, they can sue for attorney's fees, which I'm going to be repeating several times throughout this presentation. Attorney's fees drive a lot of these claims. The wage claims might not result in much, especially if someone is being paid minimum wages as a worker. And so unpaid wages or overtime might not amount to a lot of money. But let me tell you, a lot of these claims, and especially claims that I'm settling every week as a settlement officer, the attorney's fees drives the claim, unfortunately. Before we move on to when wages should be paid, the only other thing I wanted to tell you is some employers who are paying a minimum wage can get tripped up if they are not paying penalties for missed meal breaks, missed rest breaks, working off the clock. If there is an allegation by an employee who regularly gets minimum wage that they weren't paid for all of the time that they worked, that automatically means that you have failed to pay them a minimum wage. So for example, if an employee was working 8 hours a day and they were being paid minimum wage, 9 hours a day. Let's say they worked an hour of overtime every day at minimum wage. They weren't paid for that hour of overtime. That would have reduced their hourly wage to something that is below minimum wage, and those statutes would be triggered. So even though they're being paid the minimum wage for the 8 hours a day, to the extent that they have a claim that they weren't paid for meal breaks and they should have been, or that they weren't paid for off the clock time and they should have been, that would automatically drop them below minimum wage to the extent that there is 15 minutes of time that they weren't paid for. So you want to be careful about that, because you want to make sure that that minimum wage employees are being paid for all the time that they should be paid for. Let's move on to late payment at termination or resignation. I'm going to move through this pretty quickly. If an employee is terminated by you as the employer, you need to pay them the wages that are owed immediately upon termination. If an employee quits, then they need to be paid their wages within 72 hours of the last day that they worked. If they have given previous notice, then, and they said, I'm quitting in 72 hours, you need to make sure that you pay them at that last moment that they work. And that's what these statutes provide. If you don't pay them every day up to 30 days that they are waiting to be paid wages that they should have been paid, they are entitled to get waiting time penalties. Waiting time penalties will be their average daily wage for the past 60 days. And they can receive that up to a limit of 30 days, 30 calendar days, 6 weeks of work. So that means if someone, you terminate an employee and you don't pay them their wages, let's say at the time of termination, and let's say you wait 30 days to pay them the wages that were due on the day you termed them, they get another 30 days, 6 weeks of wages because they had to wait to be paid. Those are waiting time penalties, and they can ramp up and multiply very quickly in PAGA and class action litigations that we'll talk about a little bit later. Denials of meal breaks, late or uncompensated meal breaks. A Labor Code Section 512 requires employers to provide employees with a 30-minute uninterrupted meal period. And uninterrupted means they're not working. They're not working for 30 minutes. That meal period has to begin before their 6th hour of work. And the meal period has to be 30 minutes. If it starts late, if it starts beyond the 6th hour of work, it is not counted. And if it is less than 30 minutes, it is not counted. What does that mean? What does that mean for purposes of labor code violations? It means that if they took a 15-minute meal period on one day, you don't get credit for providing them a meal period, which means you could be subject to a penalty or a premium payment for that meal period. If it's happening consistently, those are situations where either PAGA actions or class action litigations can arise if you are consistently doing that. And I will tell you, I had one client who came to me seeking advice about a claim because they said the employees routinely took 30-minute meal periods and they were always taken, but they were never recorded on a timesheet. And I said, guess what? That opens up the ability that the employee and or a group of employees are going to say, we were working off the clock. We got to take lunch periods, but we were always interrupted. We had to go back to work before the 30 minutes, or no, we didn't record them because we didn't take them. And if you're not making sure that they're recording the time accurately, then you're going to have an uphill battle if a claim is filed. The same is true for rest periods. California law requires employers to provide an uninterrupted 10-minute rest period to employees for each 4-hour period worked or fraction thereof. And I can tell you, it usually works out to about, if it's under 3 hours, you're not gonna need to provide it. But if it's more than 3 hours, you better be making sure that they're taking their rest periods. Rest periods are sort of tricky because most employers and timekeeping systems or timekeeping software, it's never been custom and practice to have employees record when they take a rest period because it's only 10 minutes. It's absolutely mandatory for meal breaks. For rest periods, it's not required. And most timekeeping software, like I said, or time reporting systems don't include provisions for that. It's always something I will tell you, regardless of the type of wage and hour claim, whenever I see a complaint against a client, a construction client, there is always the allegation that they didn't take all of their meal and rest periods. So if you're in violation for failing to provide meal and rest break violations to employees, there is a way to fix this. There are a couple of ways to fix it. And I am constantly counseling clients to make sure that they are taking care of this. If you're aware that, let's say you had an employee who was working on a project and there was a time crunch, they needed to hit a milestone, and they had to work through their meal period on 5 days in 1 week. The way to get around the labor code violation is to pay them the premium payment in that pay period for the meal break that they missed. So they didn't get their 30-minute uninterrupted unpaid lunch meal period. You pay them an hour premium. You pay them an hour for the time that they missed their meal break. You don't have a labor code violation if you pay them contemporaneously. One of the remedies, if you don't pay them at all, is they get an hour for that. For each violation, they get an hour of pay. The same is true for rest break violations, which means if you have an employee in a day who didn't take their meal period or their rest periods in a day, to comply with the labor code, you should be paying them 2 hours of premium pay for that day in that pay period. If you don't, you're going to be responsible for those labor code violations along with other penalties and damages because you didn't do it at the time you should have done it. Check, I've got another question here. Waiting time penalties aren't necessarily federal law. They are waiting time penalties are a statutory requirement in California. And I can certainly provide you information about other states, but I'm not sure if the remedy is the same. But I know in California, the 1 hour premium payment is the remedy for an immediate violation. The most important thing I can also tell you is that you should be making sure that you're monitoring your employee timekeeping to make sure that they're taking their meal periods. If you determine that they're not, you should be paying the premium penalty, but you should also be talking to the employee about the fact that they are required to take a meal period in California. I have several clients who have employee handbooks, and we're going to talk about this, but this is one of the reasons why it's important. I have several clients who require this as part of their employee handbook. It's a company policy, and that gives them the ability to discipline those employees who habitually do not take their meal and rest breaks. It's like, no, this is a function of California law. We're required to do this. You have to do it. And if you keep not doing it, we're going to discipline you for that because it could lead to potential liability for us. There are lots of ways that you can ensure that. There is another way that you can protect yourself as a construction employer, and I have several contractor clients who do this. You can also have employees sign a meal period waiver or an on-duty meal period waiver. What does that mean? Meal period waivers is a document that you should have an employee sign. Is if they voluntarily agree, like, I don't want to take my meal period. If I'm just working 8 hours, I can waive it, something like that. They can't waive it if it's 8 hours, but if they're working 6 hours or less, they can waive taking a meal period altogether. So if they work 6 hours every day, but they don't want to stop and take a meal period, you can have them sign a written waiver to waive that meal period. If they're working more than 6 hours, and if they're working more than 10 hours in a day, they can waive a second meal period so long as they took their first meal period. And again, that requires an employee to sign a written waiver. What does that do? That protects you so that if a claim is made and the time records show that an employee is skipping meal periods, you have a written waiver signed by the employee saying that was my intent. And that was my intent to waive the period, and they still might get the premium payment, but they intended to waive it, and therefore they can't collect waiting time penalties or other damages that they would otherwise be able to collect. It's got to be in writing. It's got to be part of their personnel file, and it's got to be included contemporaneously. So let's move on. I've got a lot to cover still. Reimbursement of employee expenses. I'll mention this very quickly. It is part of several claims that I handle with regard to wage and hour litigations. The labor code in California requires employers to reimburse employees for necessary expenditures incurred by the employee. This issue most commonly comes up for me if construction employers are having employees use software like ExactTime to clock in and out at particular job sites and to clock in and out for meal periods. If you are requiring them to use their personal cell phone to do things like that, or to communicate with superintendents or owners or other company staff while they're at a job site, if you're requiring them to use their cell phone, are you reimbursing them for the use of their cell phone? I'm not saying that you have to pay their full cell phone bill, but what I am saying is if you are providing a mobile phone for them for use exclusively on the job site, and let's say it was just a cell phone number or basic internet usage. You know, I've done some research for clients, so we're talking about reimbursing them between $25 and $50 a month for that type of use. You need to make sure that you are considering doing that, because otherwise that could subject you to a claim. Improper practices concerning vacation pay. I'm going to go through this pretty quickly as well. Vacation pay is not outright required, but if you do provide vacation pay or paid time off to employees, then when the employee separates from the company, whether it's by termination or quitting, any accrued vacation pay needs to be paid. Otherwise, you can fashion rules that are appropriate for your business. So you can freeze accrual if they hit a certain maximum. You can, I have some clients who require their employees to take a vacation once they hit a certain number of accrued hours. And then I have some clients who require a payout of vacation so that the vacation time isn't sitting there. And the main concern there is you don't want to have an employee sitting around never taking a vacation and then leave the company, and then you're having to make a huge payout that might be an inconvenient time for you to do so. Sick time. Sick time in California is a crazy phenomenon. Under the Healthy Workplace, Healthy Family Act, employers are required to pay sick leave to certain classes of workers, full-time, part-time, temporary, or seasonal. There is a timing requirement. So even though they're a temporary or seasonal worker, they have to meet the days in the annual period worked. They need to accrue at least an hour of sick leave for 30 hours worked. The California minimum for sick time to be provided is 24 hours or 3 days a year. That number varies widely from city to city. And in fact, there are cities like San Diego that have much more burdensome requirements. Minimum 6 days of required sick time. And they require an accrual holdover from year to year, subject to a cap. But in some cities, that cap is as high as 80 hours. And in some cities, they require as much as six sick days a year. It's not uniform throughout the state of California. Unfortunately, it causes a problem for some contractor clients that I have, because I've had some clients who want to try to track where employees work, in what cities they're working on particular projects. And they would modify their accrual project to project, depending on where the employee is working. Administratively, that's a nightmare. I don't recommend it. I had a client who had a payroll employee who was monitoring things like that administratively, so that they thought they could try to save some money depending on the projects that particular employees were working on, and ended up costing them more money just to hire someone to monitor that full time. So this is definitely an evolving issue in California. There have been bills to increase the California minimum to 5 days. Those have not been successful to date, but I would not be surprised that they are introduced every single year. And at some point, especially with the flu, that's one of the main arguments, is just with the garden variety flu, that if you get the flu, you're out more than 3 days. So we got to be taking care of workers, and California is definitely a pro-worker state. Importance of timekeeping. We've talked about some of these things. There are several significant remedies in the labor code in California for wage and hour violations. Like I mentioned, minimum wage, there are liquidated damages. There are waiting time penalties, which are hefty. There are attorney's fees and costs, and there are components of PAGA damages that we will talk about. There are wage statement violations, and I didn't talk about that earlier because there's a separate code section on it, but those are capped at $4,000. But that is if you provide an employee with an improper wage statement or an inaccurate wage statement, and it could be that they didn't get paid for all their hours worked. The wage statement itself might be otherwise compliant with California law, but if there's missing time on it, it's not accurate, and you're subject to additional penalties for that. The statute of limitations on wage claims varies from 1 year for PAGA claims to 4 years, depending on what the violation is. And for wrongful termination, it's 3 years. So I counsel a lot of clients to protect themselves in timekeeping, to have an employee acknowledgement, so that when an employee submits time, whether it's on an electronic application or it's using a paper system where they're filling out a form, to have an acknowledgement when their time is submitted for each pay period, whether it's weekly or it's every 2 weeks. And this is sample language that I have recommended before. And it's simply an acknowledgement that they took their meal breaks, they took their 10-minute rest periods for every 4-hour works, and that you are making sure that you are in compliance with the labor code. I also include language about the fact that they didn't incur any job-related injuries during that pay period, and this can often help, and it's a common litigation tactic where employees will suddenly allege some sort of on-the-job injury after they've separated from their employment, and they claim that the injury was sustained while they were still employed, which avails them of the workers' comp system. And if you have this acknowledgement and you have them sign this in connection with all of their pay periods, then you have some evidence that any claim that they make with regard to a job-related injury or meal or rest break periods is false. Let's move on to documents, handbooks, policies, and other communications. I probably write well over 20 handbooks a year for clients, or update 20 handbooks a year for clients. I'm in the process now of updating handbooks to start with the commencement of the new year, in part because clients have handbooks. They haven't always been good about updating them, and California law changes literally every year. So every January, I am publishing on my blog updates about new laws that are coming into effect for employers as of January 1 each year. I recommend to my clients that they have their handbooks updated, or if they at least check in with me to see what updates are required. I have some clients that did not have handbooks when they first came to me for advice and representation. I've explained to them why it's important that they do. The handbook is the best way to manage employee expectations, and it's the best way to ensure that employees know what the rules are with regard to wage and hour, benefits, harassment, discrimination, and retaliation. That is sort of the rule book and the terms and conditions by which the employee should agree to work for you. An up-to-date handbook can document that you are requiring employees to take meal and rest periods and that you are disciplining them for not doing so. It can show exactly how you compensate employees for things like travel time. It can document how you handle sexual harassment complaints. And all of these things can be positive evidence to the extent that there is a claim ever asserted against you. You could say, no, we have a handbook, we have a policy and procedure, we followed the policy and procedure in this particular instance. And oh, by the way, in fact, the employee did not follow the policy and procedure or did not follow the handbook in the course of their employment. And so that's good evidence, and it's not ironclad. It's not going to defense a case for you all by itself, but it is going to be great defensive evidence, especially in the absence of those things existing. Handbooks. Here are some important provisions, and some are required by California law. At-will employee status. Very important. While it's presumed in California, it's always great to announce this. I have some clients that include that have separate at-will employee agreements that are a standalone document that's signed at the time an employee joins the business or the contractor. It's great to have this reinforced all the time, and we'll talk about what that means. It's required to have a policy regarding unlawful harassment, discrimination, and retaliation. Again, I have some clients, when I do training for them, they pass out the updated policy and have employees separately acknowledge the policy to use as evidence in claim prevention, but to use as evidence of notice of what the policy was as well. In California, it's required that employers have a lactation accommodation policy in their handbook, particularly something that is overlooked for a lot of my construction clients. It's something that should be in your handbook. The language is very specific. The requirements are very specific. So it's literally, it doesn't need to be a standalone policy, but it should be in there. A progressive discipline policy. This gives an employer the freedom to address employee performance issues or policy breaches or other types of breaches, whether it's a safety breach or a drug and alcohol problem. Whatever problems are encountered that require an employer to mete out discipline to an employee, you want to have a policy like this in your handbook to make sure that you have the freedom to address situations on a case-by-case basis, depending on the facts and circumstances. This also gives you the freedom to either address things in a stepped basis or in a summary basis, depending on how bad the potential violation is. Equal employment opportunity, that's a policy that is going to clearly explain what your obligations are and what your practices are with regard to employment decisions concerning employees with disabilities. And I have a couple of slides about that as well. I already addressed alcohol and drug policies. This is particularly important also if you want to put employees on notice of different types of drug testing policies. And I've spent a lot of time working with clients to determine what appropriate types of drug testing policies are good for them, and how they want to handle potential situations with employees who are under the influence. And then importantly, if you have a handbook and you are updating the handbook, whether you're passing it out for the first time or whether you are updating it, you need to make sure that employees are provided the handbook originally and all updates, and updates should indicate that they are superseding prior handbooks. And you really want employees to acknowledge that they received the handbook and that they agree to abide by it. Harassment, discrimination, and retaliation. I'm not sure if some of you here today have attended my other seminars, but I do provide prevention training for harassment, discrimination, and retaliation for California employers. California law requires employers with 5 or more employees to provide training every 2 years to all employees on how to prevent harassment, discrimination, and retaliation in the workplace. We also talk about workplace bullying, although that's not actionable. The training required is 1 hour for all regular employees and 2 hours for managers and supervisors. And if you are promoted or you join a company, you need to have this training within 6 months of either your employment or your promotion. At-will employment. In California, the relationship between an employer and employee is presumed to be at will, although it can be created as a contractual employment for a specified term or at different terms. Maybe you have a contract with a particular employee that says that you can't discharge the employee except upon cause. That's definitely different from at-will employment. At-will employment basically means that you or the employee can terminate the relationship at any time, for any reason, with or without cause, and it goes both ways. And much better to have this than to have a contractual relationship. And if you're in a contractual relationship with an employee and it's not working out for whatever reason, if there is a bound term, you could be subject to a claim for breach of contract if there are specific reasons for termination and there is an allegation that you did not meet the contract provisions for why an employee would be terminated. So in California, this is a big deal. I recommend to all my clients that they consistently reinforce with the employees that the employment is at will. Disability and accommodations. This is a part of federal law. Employers must provide a reasonable accommodation to a qualified applicant or employee. That means that they have a qualified disability. unless they can show that making an accommodation would be an undue hardship to the business. So if it would cause significant expense or difficulty, or it would result in basically, a dilution of the effectiveness of that position for a significant percentage of the time, then the accommodation would not necessarily need to be made. It needs to be reasonable. Under the ADA, employers are prohibited from discriminating against employees with a disability. And I'll tell you, I'm seeing more and more of these claims. And I had a claim that I recently settled on behalf of a couple of parties, where the employee was claiming that they had a qualified disability because they had COVID, and somehow they claimed that the employer did not accommodate them. And then when they returned to work, they were terminated. The employer's response was, we did provide an accommodation because we told them to stay home, and that is a perfectly appropriate accommodation. So the issue is typically, is the employee going to receive retaliatory behavior, or are they going to be discriminated against by the employer because they're disabled or because they're returning from a disability? And there are a number of those claims being filed in California. Accommodation requirements could be staying home. It could be reduced work hours. It could be a standing desk. It could be, we need an ergonomic evaluation of your workspace, or you need time off to attend daily doctor's appointments. There are a number of accommodations. And like I said, so long as it doesn't present a financial hardship, a significant financial hardship, or a logistical hardship on the employer that affects their business, then the accommodation should be made. Typically what happens is if an employee suffers a qualified disability, the employee typically will make a request for an accommodation. The employer has to engage in the interactive process to determine with the employee whether there is a reasonable accommodation and what accommodation can be made to the employee so that they can continue working. Failure to provide an accommodation, failure to provide it, to engage in the interactive process, are independent claims in California and are the subject of lawsuits every single day. And I have a few of them right now. Employee discipline and performance. Again, this is no different than the handbook or other employment agreements. The best way to protect yourself against claims, especially for discrimination or retaliation, is to make sure that you have a well-documented personnel file. What does that mean? If you are disciplining an employee or you are dealing with performance issues for an employee, make sure that you are providing substantive reviews, you're documenting the performance issues. And if you need to take an adverse employment action against an employee, and let's say it's for financial reasons, or if it's for performance reasons, it's for a non-discriminatory reason, you need to make sure that's documented, because I see claims constantly where an employee has been terminated and they are claiming it is for a discriminatory reason when it was for either a financial reason, maybe it was a layoff because the company was not in a financial position to keep them, or they had performance issues that were not being remedied. And the employee is going to turn around and say, no, it's because I am a 40-year-old woman and they are discriminating against me as a 40-year-old woman and not because I was a poorly performing employee. Labor code requests for files. There are 3 labor code sections where employees have the ability, some of them once a year, some of them not, to request their personnel files, their payroll files, and documents that they have signed in the course of their employment relating to their employment. Those files, if you refuse to comply with a request for files, and they very often come in advance of a litigation, you can be subject to penalties for the failure to provide the files. For payroll records, it's 21 days. For personnel files, it's 30 days. It's just a silly way to incur penalties. and it suggests or implies bad faith on the part of the employer if you don't share the files. So you should make sure that you're maintaining those files, and you should make sure that if you get a rest request that you're complying with them within the specified time periods. Claims and litigation, PAGA, class actions. Last year, over 21,000 new employment cases were filed in California. Those cases, like I said earlier, were mostly independent contractor / employee claims. What does that mean? That means that independent contractors, or people who are classified as independent contractors, were claiming that they were really employees, trying to avail themselves of wage and hour laws and obtain payment for things like overtime or expenses or off the clock time, things like that, that they would have been paid for if they were an employee, but not if they were an independent contractor. Failure to pay employees for off the clock work. Oh, I took lunch breaks, but I was always called back. So my time cards show that I took a lunch break, but I was really working. Or I clocked out at 5 p.m., but I kept working till 7 p.m. So I should be paid overtime for that time, even though it's not on my timesheets. I didn't take meal and rest period violations. Lots of cases involving that. And that is something that is, if there are other labor code violations, trust me, those two claims are always thrown in there. Improper wage and hour statements, we talked about that, even though the damages, the penalties are capped at $4,000. That's if there's another wage and hour claim, that's going to be included. And then the fifth highest number of claims filed are discrimination and harassment claims. Class action lawsuit. Some employment litigations are filed as class action lawsuits. Usually it's for larger employers, and usually it's one aggrieved employee. Maybe it's an unhappily terminated employee who has a grudge against a particular employer, or it's an employee who saw a pervasive practice by an employer not to pay overtime or not to allow meal breaks, things like that. But that person can file a lawsuit as a plaintiff on behalf, as a representative on behalf of a class of employees. The class of employees is often subject to litigation. How the class is going to be defined, who's going to be included, is it going to be multiple locations, is it going to be multiple job positions, is it going to be is it going to include supervisors or managers, and how far back is it going to go? Those are all questions that are subject to litigation if an action is filed like that. One of the big drivers for class action litigation is attorney's fees. PAGA. The Private Attorney General's Act in California is a source of a lot of discussion these days with regard to arbitration provisions. But the Private Attorney General Act allows an aggrieved employee to file a lawsuit to recover civil penalties only on behalf of themselves and other employees standing in the same shoes. So in one sense, it's similar. You can have a PAGA case that is also a class action, or you can have just a PAGA case that does not include a class action. When you have a PAGA case, that single plaintiff, like I said, can recover penalties for all labor code violations, wage and hour violations for all aggrieved employees in the company. The PAGA look back period is 1 year from the date of the last violation. So while it's a shorter period of time, it could potentially involve multiplied damages for several violations. And most of the violations are levied per pay period. So it can be extremely expensive. Another reason it can be extremely expensive is because although it's a vehicle for getting penalties and additional monies, most of those monies go to the state. So PAGA is supposed to allow a single plaintiff to be the watchdog, to be a single plaintiff is empowered to seek vindication of the rights of multiple plaintiffs when they don't have the ability to otherwise have that done by the state. Plaintiffs need to jump through some hoops to file a PAGA claim. They need to send a formal notice letter to the LWDA, the Labor Workforce Development Agency. This is a a highly coordinated online process now. Most of these things are completed online. The notice letter needs to be served on the employer. One of the things that an employer can remedy once they get a notice letter to avoid penalties is to cure wage statement defects. Most of the time that's not feasible, because if the wage statements are inaccurate because there's a dispute about whether time was owed or not, so unpaid overtime or working off the clock, it's really difficult to correct wage statements when you don't know what the scope of the other disputes are. But if it was simply the wage statements recited the incorrect employer or the incorrect address, that's something that could be easily remedied. And if you remedy that after you receive the notice letter, then you can cut off some of the claims and penalties. The notice letter is designed to give the Labor Workforce Development Agency time to determine whether they're going to investigate the employer or not. As with most other types of claims in California that the Department of Fair Employment and Housing handles, the LWDA doesn't have the time, resources, or ability to take most of the cases on. So what they'll do is let the 65 days lapse. If they don't respond back to the employee, then the employee can go ahead and file their own lawsuit under PAGA and seek the penalties. As I said, 25% of PAGA recoveries, the penalties for the group, are paid to the individual aggrieved employee, and 75% are paid to the state. Usually when those cases resolve, there is an allocation made. If there are individual claims and PAGA claims, there's an allocation made between the individual claims and the PAGA claims, and plaintiffs' lawyers like to allocate smaller amounts to the PAGA claims because they know they're giving up 3/4 of it. The other thing that drives a lot of PAGA cases is the fact that you can recover attorney's fees and court costs, which means that plaintiffs' counsel, very often we see plaintiffs' counsel claiming $1,000 hourly rates for prosecuting cases like this. They know it might be reduced, but that's where a lot of the money is to be made in these litigations. The other important thing to note is if it's a PAGA only case, then individual owners of a company, I had a contractor this week ask for recommendations on whether they should be settling a PAGA case because the plaintiff's lawyer was seeking discovery of individual financial records, not just the construction LLC's financial records. And unfortunately, if it was a PAGA only case, if it's a PAGA only case, then they can recover the PAGA penalties from the owners and their individual assets as well. Documentation, I think we've talked about this. I know I'm running very short on time. I've gone over. I'm going to try to finish in the next few minutes. Important to document reviews regarding performance. Performance improvement plans are a great vehicle for employers to track poor performance and give an employee the opportunity to correct performance. And if it's not corrected and you have a PIP in place, then you have much more freedom to take actions that are going to be justifiable if you want to terminate someone. Separation agreements are really important, and I highly recommend them because they usually include a release, which means that if you are giving an employee severance and they sign a separation agreement, they are signing a release from making any claims against you following separation from employment. Very, very important. Pandemic policies and IEIPPs, I'm going to go through these pretty quickly. Pandemic policies, I've drafted standalone policies for clients. I don't necessarily put them in the handbook because they're ever changing. It's fine to have a standalone policy. I have a lot of clients who are dealing with claims now because they were not aware of what the sick time requirements or what the Families First or other COVID laws required them to do. Really important to stay abreast of this, both in terms of state and local requirements and OSHA requirements, which right now some of the OSHA requirements are more burdensome than the state and federal requirements. OSHA also has the ability to show up at a job site or a workplace and conduct a site review and make recommendations. So you want to make sure that you are aware of what the policies are. Illness and injury prevention plans. In California, every employer has to have an illness and injury prevention plan. It's a separate written document. It can be part of your handbook. It can be a standalone policy, but you need to have one. It has to, it should be in writing, and it should identify who's responsible for monitoring and implementing the program. It should identify and evaluate hazards. It should require inspections. It should talk about how you correct unsafe or unhealthy conditions or practices in the workplace. It should talk about training. It should talk about reporting, communication and reporting if there's an emergency or there are hazards that need to be dealt with. It should talk about discipline and enforcement for violations. And it should talk about record keeping, how you keep records of training and monitoring and investigation and correction of hazards. Immigration issues, really quickly, we're getting towards the end. I promise it's going to be like 3 minutes. Every employer is required upon the commencement of an employee's employment to verify their status using an I-9 form. There are electronic systems as well, but you need to make sure that this happens within 3 days of their being employed with you. If not, I have handbook provisions that requires employers to consider it a voluntary resignation if the employees do not comply with the employer's request for immigration documentation. If you do not do this, if you are not following these rules, you could be subject to civil fines and criminal penalties. You could be subject to discrimination actions against immigrants. So you want to make sure that you're complying. And I have several clients who use electronic systems, and if there are hits, they need to make sure they go back to the employees and follow up, and you need to stay on it, because if you don't get the documentation issues, or you don't clear up issues, maybe with an incorrect social security number or things like that, you can get into a lot of trouble. And I have clients navigating those issues right now. Importantly, insurance. So California is rampant with litigation. It's a very expensive process. If you're not taking care of these things on the front end to ensure that you don't get sued, how do you handle employee claims and lawsuits? There is EPLI insurance coverage. It's employment practices liability insurance, and it covers employers for things like wrongful termination suits, discrimination, harassment, retaliation lawsuits. It's expensive coverage. It usually includes a high deductible, but the great thing about it is it provides you with a defense. So if you're being subjected to meritless employment related claims, it very well may be worth your while to investigate whether you can get EPLI coverage. Most EPLI policies previously never provided coverage for wage and hour lawsuits. Now you can make sure that that coverage is included in a policy. It's going to cost you more money. And the amount of the premium you pay very often is excessively high. It just depends on what deductible you're looking for and whether you have a prior claims experience. I liken it to earthquake insurance for someone who is living on the San Andreas Fault. If you have a bad claims experience, or if you are concerned about being able to afford the defense of employment litigation, you should consider looking into it. Okay, I rushed through some of that in the back, but I'm wondering right now if there are any questions. Please feel free to put them in the question box and I will be able to answer them. No questions. Well, let me, here's my contact information. If you have any questions, feel free to email me. I'm happy to answer questions by email after the fact. I know that you'll, and also please share with me your email if you have any, if you would like a copy of the presentation.
Thanks so much, JoLynn. That was a very informative presentation. So much to soak in there. And thanks everyone for sticking with us and getting in the extra knowledge that JoLynn had to share. So that concludes our webinar today. And please follow up and contact JoLynn if you want to connect with her and have any questions, or maybe you heard something that could help your business today. I know she would be happy to hear from you. So
Great. Thank you.
thank you. Okay. Bye, everyone.